Thank you, Richard, and welcome everyone to the final presentation of the day, Financing Real Property Acquisitions. As Richard mentioned, my name is Stephanie Harvey, and I'm a lending lawyer, and I practice at the Gowling WLG Hamilton office. I will be moderating this presentation. Quick housekeeping, as with previous presentations, I encourage you to put the questions into the Q&A chat, and I will be monitoring that throughout the presentation and either interjecting if applicable or waiting till the end to pose those questions. A mortgage is central to a lender's security on a real estate acquisition financing, but so too is an understanding of the real property purchase transaction. Our real estate lawyers will walk us through key aspects of a real property acquisition that bankers should turn their mind to in the context of a financing, including review of a purchase agreement, title and off-title due diligence, title insurance versus title opinions, and common areas of negotiation. So without further ado, I'm pleased to introduce two of my colleagues, mentors, and friends, Pamela Green and Mark Gevedoni. Both Pam and Mark are senior partners in the commercial real estate practice group with the Gowling WLG Hamilton office. Pamela's practice encompasses a comprehensive range of commercial real estate matters. She also sits on the firm's executive for the National Real Estate Industry Sector Group, is a member of the firm's National Expropriation Law and Municipal Law groups, and heads up the Real Estate and Condominium Sub-Practice Group. Mark is a dedicated strategic advisor in all aspects of real property transactions and a member of the firm's National Expropriation Law Group and National Municipal Law Group. From multi-million-dollar infrastructure and private-public partnerships to land conveyancing and transactional due diligence, Mark is equipped to act as a single source of real property advisor. Thank you to Mark and Pam for being with us this afternoon. If we can put up the first slide. Oh, first slide, please. What Pamela and Mark would like to do today is look at a situation where a borrower might need your assistance with respect to the purchase of a commercial property and explore what you as a banker lender should consider and how you can be of assistance to the purchaser borrower's prospective client. So let's move into the fact scenario, which will underpin much of today's discussion. Your client is looking to purchase a commercial multi-tenanted building. The building itself is located in an older part of town. The purchaser is looking to add an addition to the last unit for a new lab facility tenant. This tenant will be the anchor tenant of the property, which means that the largest payment stream of the property is not already contemplated there, and the source of income is not yet in effect. And on top of this, the use of the addition as a lab is not one that is yet contemplated at the property. So bearing all this in mind, I'm going to turn matters over to Pam and Mark to take it away.
Great, thank you. So we set out this scenario because there are many, many different situations we could talk about, but we wanted to use this to bring out some specific examples. And so Mark and I are just going to go back and forth to talk about some of those. And we're going to start with the next slide. One of the things we want to emphasize during the course of our discussion for the next hour almost is the importance of asking questions and knowing the purpose. The purpose of the loan could vary. The purpose of the loan could be hidden, but all of it could lead to questions that need to be asked and answered, different forms of due diligence, different forms of documentation, and that sort of thing. So we're hoping to take you through some of those scenarios. So I'm going to start by turning it over to Mark. So what is the true purpose of the loan and why does it matter?
Well, understanding the purpose behind the transaction is critical to understanding the type of loan that's necessary. And it may be a straightforward loan, a conventional loan. It may actually change over the course of the transaction and the purpose. So, for example, if it's to construct something, that will be a very different loan than if it was to buy the property. Or maybe it's a loan that does all of those things over the course of a period of time. That will change your due diligence, that will change your security. So it's important to ask the question so you can prepare and tailor the loan accordingly.
So starting with priority is one of the biggest reasons. In our little fact scenario, we talked about there being a purchase of the property, maybe construction or leasehold improvements to a separate unit at the end. And so we were talking about at the end because we do want to say that the unit itself is going to be extended. So we are talking extension or talking construction and leasehold improvements. So priority then becomes a key issue because priority for the purchase loan where monies are advanced at one point is governed by registration of the mortgage. However, any other type of loan that has advances made over the course of time could be subject to priority issues, and therefore it becomes very important to talk about what type of loan it is and how it is secured and when it is that you are going to conduct searches to ensure that you are maintaining priority over every advance that is made. Mark?
Yeah, I think that's exactly right, Pam, in that the issue of priority can shift over the course of the type of loan. If it's a construction loan, there are multiple advances contemplated, and priority could shift with subsequent advances. If it's a revolving loan versus a fixed term loan, the concept of priority can change as well when you can have intervening interests pop up in between there. It's a little bit sneaky, but it does happen from time to time, and it's important to be guarded about it. And the easy way is to ask, what am I loaning against? What am I loaning for? And that should then trigger a response in terms of verifying priority at critical times throughout the loan's life cycle.
What it could also mean is that intervening registrations need to be dealt with. If a second mortgage is registered, then a first mortgagee making a subsequent advance will want to make sure that they maintain priority. That may require a priority agreement. That may entail the second mortgagee agreeing to either postpone on title or at least postpone contractually to the first mortgagee's subsequent advances. And those are things that we would only find out if we do those searches. So always important to conduct additional title searches. It may also be important to conduct other types of searches on subsequent advances, and they are more for information purposes as opposed to priority. As an example, it would be good to know that realty taxes have been paid in full prior to any subsequent advances because those, of course, take first priority. They don't need to be registered. They, as of right, take priority. The other thing might be to conduct execution searches. And again, it's just for information. Hopefully nothing has been going on with your borrower that you aren't already aware of. But as a matter of prudence, you may want to conduct an execution and make sure no writs have been registered against your borrower.
We might also, through the initial due diligence, if we're looking at our fact scenario, understand that we're acquiring a property that may already have a couple of minor tenants in there. And it's also important to consider that the tenants may have registered notice of their lease on title as well. And as a result of that, the lender may assess that we need to subordinate the provisions of that lease to the new loan security that's going to be registered. Again, for reflecting that priority becomes an important issue in the loan transaction, that we'd look to not only postpone and subordinate other debt instruments, but also other interests like leases.
Which leads to lease review. So one of the important pieces in due diligence, and whether it's done internally by a lender or externally by counsel, is to review the leases. If the borrower's income stream is the thing that you are securing against and agreeing to provide a loan for, it's important to make sure that those leases are in fact legitimate. So one thing to make sure of is that there is a term that is still in progress, that it's not a term that's going to expire in 2 days' time, and it's not a term that could expire in 2 days' time because there is a termination right in favor of the tenant. So what we do is we review leases from the point of view of substantial provisions and what may affect the income stream in order to substantiate that income stream for the lender. And we'll talk a little bit more about on title for the leases, but let's talk for a second, Mark, about construction. In the nature of our little scenario does have some construction. So we're not going to get into a lot of detail on construction financing because that could take up a whole session in and of itself. But we did want to note some things when it comes to construction contracts and due diligence, and that is in the same vein as your lease review, you should be reviewing the contracts that your borrower is entering into. You should be taking a look at whether or not there is one general contract or several contracts, in which case you have an issue with when lien periods run. One of the great reasons to have one general contract and everything flowing underneath it is that the lien period will run upon publication of substantial performance for all of those entities at the same time, as opposed to needing to find out when the lien period runs from each and every contract. Mark, any other thing on construction contracts without getting into too much detail?
Yeah, I think that again, looking at the purpose of the funds and asking the questions of the borrower is important about the structure of the construction activity. Is it multiple contracts? What's the size and the value of the project? Does it require an entire site plan? Does it just require a building permit? Getting into that, because part of your security may end up being that you want an assignment of those contracts as well. So understanding the fulsome intention of the borrower to use these funds will help facilitate the proper security panel. In turn, if you had collateral type mortgage security that was intended to protect for both the underlying loan, the acquisition advance funds, and that it would subsequently convert to construction loan, you can have an umbrella mortgage security, but that again doesn't remove the obligation to ensure that subsequent advances are held back. The proper loan construction holdback amount is held back from each subsequent loan advance on a construction loan, and making sure that the security dovetails with the type of loan and the purpose behind it.
So one last comment on that is to know what the experience of your borrower is and who it is that they are using. Very often we're asked the question of whether third-party oversight is a good idea. That is most often driven by the magnitude of the loan, but most certainly having a third party providing certificates of work completed to date and payments made to date are extremely beneficial and should always be at least considered. Next slide. So now we wanted to go into a bit of the due diligence that we might be doing more on a legal side, and the reasons why as a lender you might also want to be concerned and may want to become involved prior to your borrower entering into an agreement of purchase and sale. So we're going to start with heritage. One of our facts in our little scenario was that this is a building located in the older or an older area of town. And so, Mark, can you tell us a little bit about the difference between let's start with the top 3 bullets: being designated, being listed, or being a property of interest to a particular municipality.
Right. So the Ontario Heritage Act has a process whereby buildings, structures, or locations in a municipality can be flagged for having heritage or cultural value, or being seen as properties of interest for that purpose. So the implications of that are far-reaching, and they're along a spectrum. A property could be considered of interest if it may have some historical, cultural, or other significance to a community. And that could be local, it can be territorial, it can be provincial or national in scope. But usually it's the municipality will look for designating or noting if there's a property of interest. And if there is a property of interest because it has some of this value in it, they can list it in a municipal register that would essentially preserve a thought process or an opportunity for the municipality to more fulsomely consider those attributes that give it that cultural value or heritage value. So if it were to be listed, you couldn't demolish, and don't think necessarily just blow it up, but it could also mean to start taking things apart, start dismantling, anything along those lines. You can't do that. You would not be able to get a demolition permit for at least a 60-day period. That would give the municipality an opportunity to do a deeper dive and potentially consider designating the property. And if the property is designated, there's a little bit more of a fulsome process and a review. It's getting a little bit better to be a bit more open. But that process would then ultimately, if it were successful, to designate the property as having heritage value. Those attributes would be highlighted and then would be enshrined in a bylaw that would then may or may not include a restriction or an easement that would apply to the property. So for example, if it was a very unique example of a certain period of architecture, then the designation may say that those attributes that give rise to that architecture cannot be altered without a permit. Therefore, there may be some implications.
So, Mark, in our fact scenario, the borrower is contemplating extending a unit at the end. And so, further to our fact scenario, on the other side of it is a collage that has been painted over the years by the community. This is actually a really big issue in a lot of smaller communities. So we had wanted to extend the unit, or the borrower had rather, and they may not actually be able to do so. Or they may be able to do so, but there will be a cost to it. They would have to take down brick by brick and reinstate the wall on the end of the extension. So sometimes what it means is that the project that the borrower thought would cost $100 is now costing $110 in order to deal with the heritage issues attributed to a particular property. So do you want to move on to zoning, Mark? I'm going to set the stage for you a little bit here. In our fact scenario, we specifically talked about a lab facility and a new tenant. And the reason why we set those out is because the lab facility is not an existing use. And Mark will talk about whether an existing use is the end all and be all. And we were talking about it being a new tenant. So that tenant is going to carry on a new type of use, and that type of use doesn't currently exist anywhere else on the property. Mark.
So it's important to understand what is actually permitted and what the existing use is of the property, so that one, you can verify that the existing use is still allowed. And more importantly, if there's a proposed use, that will also be allowed. And if not, what steps can be taken to to render it an acceptable use. So initially, you can conduct searches of the zoning bylaw, or you can write to the municipality and say, hey, this property has this type of use already going on there. Is that permitted within the zoning bylaw? Oh, and by the way, we also want to add this lab use as well. And is that permitted within the existing zoning bylaw? And the municipality will respond in multiple ways. Yes, no, maybe so. And it's understanding then, if the answer is no to the proposed use, that now you're into an investigation of what are the opportunities to make it an acceptable use. An acceptable proposed use can either take the form of minor variance, and there's a test as to whether a variance from the zoning is minor or not, or it could be a full out rezoning application. And that's a much more convoluted, lengthy, and costly process to ensure that your use can be utilized. It's also a public process. So if the adjacent properties, the owners of the adjacent properties are less inclined to allow this new use within that zone, there could be some public objections as well. So understanding that is really helpful.
So the issue there really is that you need to determine zoning long before closing. And you need to be making sure that the borrower is looking into that prior to entering into an unconditional deal. So Mark, let's talk a little bit about title and other things that we might look to or look for when we're reviewing the possible purchase under our fact scenario. So when we look at title, we're not just looking for whether or not the description of the lands is correct. We're looking for what else affects title. One of the things that we see very often are restrictive covenants. Restrictive covenants could be that the building has to be built with red brick. But restrictive covenants could also be that there shall be no more than one restaurant. It could be that there shall be no lab facilities, which of course in our situation is really important. But those restrictive covenants do have to be reviewed. Who benefits from the restrictive covenants needs to be reviewed because you could get consent. And if the restrictive covenants have been complied with to date, we'd also look at whether or not there is a way to kick them out because they are not negative in nature. Restrictive covenants that are not negative in nature do not run with the land. And restrictive covenants may have limited time periods. Again, we would look at whether or not we could delete restrictive covenants for that reason. CPUs, Mark, you want to talk about certificates of property use?
Yeah, certificate of property use is a tool and a mechanism under the Environmental Protection Act predominantly, where there has been some environmental activity or a process to start an environmental assessment or audit for the purposes of remediating the property. Ministry of Environment will issue certificates of property use to restrict the types of uses that can happen for a period of time while there's ongoing monitoring or remediation that could be involved on the lands. So understanding what a certificate of property use is, how far it extends, and if it restricts the intended use is very important. Otherwise, it could upset the existing environmental regime that's in place.
It could mean, for example, that the borrower can't construct the addition that it wants to construct. So we're always going back to what is the really important part of this loan. The new lab tenant with its $1 million rental income stream. We have to look very carefully about what may affect that income stream and the possibility that there is fly ash that is sitting under the concrete parking lot, which is subject to a do not disturb order under a certificate of property use, then becomes really important. So development agreement. Yep.
Oh, I'm sorry, Pamela. Just to note also that the regime for the certificate of property use and the environmental regime that could affect the property it talks about types of use that are permitted and not permitted, and those are completely independent of what the zoning is. So a zoning use is a municipally defined use, but the environmental uses under a certificate of property use or the Environmental Protection Act are actually a little bit different. They mean different things. So when the environmental one says commercial, that doesn't necessarily mean the same types of commercial that you might find under the zoning. So it's important to distill that as well if there's a certificate of property use in play.
So development agreements, very often we see some form, subdivision, development, financial agreements that are there because of either the subdivision that the property is located in or the property itself. And we review those from the point of view of what may be outstanding. So we write the typical letter off to the local municipality and we ask the question. Now, the answer to the question very often is it's been complied with to date and there are securities in place. When we see that type of answer, we really want to know what is still outstanding or could be outstanding in the future. Again, a purchaser buying a property that's subject to a development agreement really doesn't want to find out that there is a $100,000 exercise next month pursuant to covenants under that development agreement. So important to find that out. Mark, on development agreements or any of those types of agreements, the municipality is going to look to the current owner. And so regardless of whether the covenant originated 20 or 30 years ago, if there is a grading covenant that has been breached in between, the municipality is still going to come to the current owner for rectification. So other comments on development related agreements?
I think that's the important one, is that you mentioned with the restrictive covenants that the positive ones don't run with the land. In a development agreement with the municipality, they certainly do. So it is a hot potato situation. Whoever is the owner at that time, the municipality is likely to go after. So it's a key takeaway.
Okay. Let's go on to the next slide, please. So we're going to talk about a couple of main terms in an agreement of purchase and sale, but as a lender, it's also a good idea to review the terms of an APS and if possible, to have input in it before it is signed by the borrower. A couple of the reasons why. We'll start with environmental. Obviously, as a lender, you want to make sure that you are protected from any environmental liability. I've, in the last seminar that we gave, talked about some of that and how a lender could be exposed. But what you really want to make sure is that your borrower is not exposed to begin with. And that's the same for basically all of the comments that we have been making, is that while a lender may be made whole, it would be really good if the borrower didn't run into some of these issues and therefore go belly up or not be able to properly service the loan. I think the phrase we were talking about, Mark, was we would really like your borrowers to be repeat customers, and therefore we want to make sure that full and complete due diligence is being done. So reps and warranties, I'll pass it over to you, Mark.
Right. So the environmental regime in Ontario specifically is pretty comprehensive, and liability can seep in many different ways. So ensuring that there's proper representations and warranties in the agreement of purchase and sale that not only protect the borrower, but then also could be utilized to assist the lender when the borrower is able to rely on the seller of the property for historical environmental problems or issues. So particularly when lenders will have an environmental questionnaire, sometimes the borrower may not have all the information at that moment. So factoring the needs of the lender into the terms and the reps and the warranties that the borrower can get from the seller in the agreement of purchase and sale will help to dovetail and make that hopefully a bit more of a seamless process and give the borrower some confidence in being able to make the attestations that are required in the lender's environmental audit. questionnaire.
So moving on from that, Mark, we wanted to specifically point out approved list of engineers. A lot of lending institutions have an approved list, and you really need to make sure that your borrower is aware of that list, because the cost can be fairly significant if there is a non-approved engineer, and the time that's lost as well as the cost could very well be quite detrimental. So approved list of engineers, and what is it that the vendor is passing over? So most agreements of purchase and sale will require a vendor to deliver what they have. And sometimes it will have a covenant to not only deliver the reports that they have on hand, but also to deliver a reliance letter. That would be the most ideal for borrowers and lenders, is for the vendor to have that obligation, and for lender and borrower to be able to rely upon existing reports. Now, existing reports are really only as good as the paper they are written on and when the inspections were done. So this holds true not just with environmental, but also with respect to building condition reports. And so, Mark, do you want to talk about, I'll call it the 18-month rule?
Right. It's how stale is stale. What we're looking for is a means that the reliance letters are accurate. In an environmental context specifically, relying on stale or older reports may be a problem, because they will the environmental standards may have changed, and that has been the ongoing situation for the last couple of decades. Is that the tables in the ministry guidelines and regulations keep shifting. So a phase one that was done 5 years ago may not actually be accurate any longer. So the 18-month rule, while it's not a fixed legal rule, is we can say a rule of thumb that would generally apply to when reports were originally commissioned, and whether you actually want to rely on them as a lender.
Okay, so how about let's talk about leases. I talked a little bit before about lease and rent roll review, and making sure that the leases coincide with what the rent roll stipulates. Again, because in all likelihood, lenders are given a rent roll, but not necessarily the leases to begin with. So helping to substantiate those numbers is important. But beyond that, when we're talking about an agreement of purchase and sale, one of the terms that should be included, at least from a purchaser's point of view, is that estoppel certificates are received from the tenants. And that's because you want to create a situation where a tenant cannot come back after closing to say, wait a second, I had a special deal with the landlord. The landlord was giving me the next 6 months free because I had a leak and I had to fix the leak myself, or whatever nonsense or factual circumstance they may bring up. So what the estoppel certificate does is it prevents a tenant from saying something different after the fact. Again, part of substantiating what that rental income stream is, and making sure that any issues that exist are brought to the forefront. Just because an issue is brought up does not mean that it is the end of the world or the end of the transaction. It may just mean that there is a purchase price adjustment, an undertaking to fix something, or a realization by the purchaser that they're not getting quite what they thought that they were getting. In any event, it is important to get estoppel certificates from as many tenants as possible. Sometimes the agreement requires 100%. Sometimes it may just require a certain percentage, again, so that borrower can substantiate as much of the rental stream as possible from a third-party source other than the vendor who just wants to sell the property. Mark?
And as the lender, you are quite interested in that. You may actually make your case for the loan based on the perceived rental income, and so understanding the status of the leases through an estoppel certificate may actually be a critical condition precedent for your loan. So it's not something necessarily to be glossed over. Similarly, a review of the leases should identify that, one, the estoppel certificates are obligations of the tenant, so that there's more or less an understanding that they will be provided for closing because they're obligated, but also the interplay between existing tenants and you as the lender coming into the situation. And so the subordination and non-disturbance provisions in the lease are important to look at as well, because this will in turn impact whether the lender is able to enforce properly against the property and the tenancies. In many cases, if there are provisions in the lease, they are to be subordinate to the incoming lender. And in many cases, that subordination is also tied to the provision of a non-disturbance agreement, so that the lender will agree, if the tenant is not in default, to allow the tenant to stay in accordance with the provisions of the lease. But in exchange, they are subordinate to the lender. So that's important to consider as part of your due diligence.
And absent that, Mark, if you look on title and you do not see a lease or notice of lease registered against it, that lease may still take priority. In our different title system regimes in Ontario, land titles versus registry, land titles, conversion, qualified, and registry, leases that are 7 years or less would take priority to a mortgage. And in land titles absolute, 3 years or less would take priority. So you do want to make sure that the leases are in the correct order that you would like them to be. And if you are loaning against something that is registered, that you may need to require postponements. And that will depend upon the length of the lease. A 10-year lease that burdens the property for the next decade might be something to consider postponing. And if it's not part of the lease itself, you may have to have your borrower negotiate something outside of the lease. So a 10-year lease is probably a good substantial rental stream, but a 25-year lease would not necessarily be, and you would have to have a different discussion on that one. Is that good for that, Mark?
I think that's perfect.
So next slide.
slide.
Do you want to start, Mark?
Sure. I think it's important to have this discussion on title insurance because it seems to increasingly be perceived as a stopgap. And part of the important elements is that it has a very specific role and function, but title insurance is not necessarily the same for the lender as it is for the borrower who's going to be acquiring the property. Generally speaking, most title insurance products that are out there are more lender friendly because there's more coverage for more issues that could arise for lenders. But it may not actually provide coverage for the borrower, or it may not be appropriate coverage for the borrower. And so it's important to understand the differences and to canvass what due diligence is still something that should be pursued, even if title insurance was in the picture, and which may be more appropriate to rely on the policy and coverage under the policy. The element here is the difference. Title insurance is an alternative to a lawyer's opinion on title, and usually, if that's the way that they're proceeding, the lawyer will review title and search title, adjoining properties, all the instruments on title, and then a whole regime of searches off title, from taxes and heritage and zoning and environmental and files from the municipality and the province. So that's a pretty comprehensive investigation to ensure that there's nothing else out there that's going to impact good title and marketable title, and ensure that there's good quality of title that's being acquired. There's pros and cons that are associated with both. Many cases, it's a matter of timing. Sometimes it's a matter of cost, because all those searches do require government fees for the inquiry. But in the end, it's what's being what are you getting coverage for? And so Pam, maybe you can take us through some of the pros and cons of the of full searches or an opinion or title insurance as seen in some of these bulleted points that we've highlighted.
So yeah, I want to take us back to our fact scenario and just how important it is to be looking at what the borrower is doing with the property. In this scenario, a lender may be just fine. They can get title insurance. We can close in a few days' time without doing full searches. And the lender in all likelihood will be made whole. But the borrower here, and the one that we want to keep as a continuing customer coming back from time to time, they would be in a really bad situation if these searches had not been done. We know that the new tenant coming in with a new use really needed us to look at zoning, and if zoning did not permit it, then perhaps the purchase price was too large, or perhaps this particular borrower purchaser should have not waived conditions. So the not doing searches but having title insurance in place may not be sufficient for the borrower to get what the borrower thought that they were getting. In this case, a lab tenant that would be the anchor tenant for this entire plaza. The full searches is really about a matter of knowing problems in advance. In my opinion, has always been, you are much better to know it beforehand and to deal with it beforehand than after. Sometimes that's contractually because you can't go after the vendor once you've closed. More often, along the lines of what we've been talking about, it's about knowing what you're getting into and whether or not it is worth it. So knowing in advance that your construction costs are going to be 10 or 15% higher because of environmental issues, because of heritage issues, and because of zoning issues where you require a minor variance. All of those things are factors that you want to know beforehand, and title insurance doesn't fix that problem. But let's look at what title insurance may fix. Lawyers making mistakes? Yeah, technically. We'll just keep going from that one. Fraud. A new borrower is more likely to be one where fraud could occur. I see never on the chat. So knowing who the borrower is, or the lawyer having dealt with a particular borrower entity for a number of years, those types of things help to prevent fraud from occurring. But we can't see everything, and we can't search everything in order to determine whether fraud is existing on a transaction. So that is one situation where title insurance is very helpful. Title insurers have also started offering some new post-closing coverages. And so two of them here are where the borrower builds without a permit and therefore causes a decrease in the value of land. Your lender policy is going to make you whole. Super priority liens, and again, this is something lawyers just can't search on their own, or at least on a timely enough basis for any transaction to occur. So those are a couple of situations that we thought we would mention there. Title insurance does, however, allow a situation where a deal can close sooner. So if you have some base facts in your borrowing scenario where land is being bought, it's already tenanted, there aren't any renovations or construction related things that are going to occur in the short future, those base scenarios, they might mean that a quick and dirty title insurance, less than full searches, is something to pursue. The less than full searches, all title insurance policies do require some searches, so it depends upon the level of coverage and what the title insurer may require to go along with that policy. But there are some base searches that are always done. Mark, do you want to add to that?
Yeah, and it's to ensure that they fit together as a puzzle. And in many cases, there may be some qualified limited opinion that is required from the lawyer. Indeed, the title insurance policy itself is an opinion to the title insurer. And to look at what the coverage options are so that they can actually integrate, not only just for the sake of getting the transaction closed faster, but also to ensure, as we said at the outset, that the borrower has something that they can use tangibly to make to move forward with the acquisition or the future expansion in our fact scenario. And they're not going to be caught off guard with a situation that's going to be a problem, or that title insurance can't cover as well.
So, Mark, we didn't say it at the beginning, but we actually sort of tried to time this out so that we had time for questions. So if people do have them, if you could now enter them in. Let me just make sure.
Oh, I was just going to say that there's one there now. So if you guys are ready, I can pose that. The question we have now is, should the due diligence searches be conducted right away, even if closing is 3 months away, or should it be sometime closer to the closing?
So as a general rule of thumb, I look at the timing and when a client wants to spend their money. So if you have a conditional deal and it's conditional for 30, 60, or 90 days, that really is what dictates when we start doing our searches. If you only have a 30-day conditional period, you need to start your searches right away, because otherwise you won't get them done in time. If it is a 60 or 90-day period, you might be able to delay that start and save your client some costs, because your client, and I'm talking about a borrower really here, a borrower might decide that they don't even want to go forward with the transaction within the first 30 days because they have been into the local municipality to ask about whether a lab use is okay, whether this expansion would be palatable. They might have had some preliminary discussions which already killed the deal, in which case we don't want to have spent their money yet. Mark, anything to add to that?
Yeah, just to keep in mind that the last 2 years have been pretty difficult in various industries. So the timing in conducting a number of these searches has actually expanded exponentially. So it may have taken 3 weeks or 2 weeks to do a zoning search in the past, and now it may take a month. So understanding what types of searches are going to be required for the due diligence period. Some can be started sooner rather than later, but we don't want to be caught in a situation where you have to have a certain piece of due diligence, but you know that it's going to take 40 days for that to actually manifest. So enough time lead time is great.
Steph?
Okay. Next, so the next question that we have here is, as a lender, since we have different title insurance coverage, should our counsel ask the borrower's lawyer about the due diligence searches and ask to see them, or should we just rely on the title insurer?
So I think that's the theme of what we've been trying to say. I think you're better off knowing about the problems. You are better off knowing that your borrower is doing proper due diligence and not getting themselves into trouble before you've even, advanced the loan. So there are certain searches where certainly what we do is we rely upon the borrower's counsel to conduct the searches, and we just do a quick overview of them. And then don't do separate searches. That way you're saving the double or the duplication of expenses. But in my opinion, yes, you could rely upon title insurance, but I don't think that helps on a go forward basis. And you're better off conducting, or at least reviewing, what has been conducted.
And you want to know where the borrower has already been in pursuing their investigations of the property. They didn't just wake up and say, this is the property I'm going to buy. They've probably already started some work. So to avoid the duplication, but to understand where they've already searched and what types of inquiries they may have already unraveled. And that dovetails into the title insurance coverage as well. So.
I don't see any other questions yet. So feel free to put them in. One question that I often get from my lending clients having to do with leases on title is when, if ever, is it appropriate to allow them to remain in priority without obtaining the postponement? There's often times where we'll get a lot of pushback on it, and from the tenant who's on title. So can one of you speak to that?
Well,
Mark?
it's really factually dependent. I mean, if you have a month-to-month tenancy, it's not going to be much of a problem. If you have, 2 years left in a tenancy, and they've historically been, in a good position, and they may not be as material to the transaction or whatnot, then there's opportunities to consider what you can, from a lending perspective, what you can get in lieu of subordination or postponement. But generally speaking, it's that would really rear its head when it's time for enforcement. So you don't want to be caught off guard there.
There is one subject I want to talk about quickly. The difference between a general assignment of rents and a specific assignment of lease, because I think this is often a mixed up concept. So I am often asked to get a general assignment of rents and leases and a specific assignment of lease, which is just a two-party document between borrower and lender. But it talks about a specific lease. To me, that is an extra piece of paper that is completely superfluous and not really useful. You need the tenant to be a party to a specific assignment of lease. To have it add anything more than the general assignment of rents and leases. So if that's a requirement of your security list, then you need to be careful about that. Sometimes that's one way to get your tenant into a postponement, by having that contained within the language of the specific assignment of lease.
Okay, and then another question has come through. What are likely issues to note when the owner is a general contractor handling multiple construction contracts in a construction project being financed by a lender?
So the owner is a general contractor. So this is what we had started to get into a little bit. The issues really start with, is that owner, or does that owner have any experience? Being your own GC is not actually fun. It is a lot of work. And so I just start there as an overall comment on, not all borrowers should be general contractors. Then you get into the issues of, when do your lien periods run? And maybe I'll let Mark speak a little bit more about that, because when you start to make payments and you've withheld your proper holdbacks, knowing when you can release those holdbacks now becomes contract specific. And again, that just leads to a lot more work that needs to be done and a lot more due diligence. Mark?
Yeah, there's also some misinformation about when those holdbacks can be released in the context of individual subcontracts or the project as a whole. If it's a larger project that has a payment certifier and it's being coordinated through a consulting engineer or an architect, that makes a difference as well. So it's important also to know if it's for a residential construction or if it's non-residential construction, because that may impact other ancillary issues as well, particularly for construction liens and other regulatory items, like if it were a condominium or for Tarion. So those are very specific in terms of trying to ascertain those obligations, and those are also lender obligations as well, in terms of what the lender needs to be holding back from those types of funding arrangements.
Okay, well, we're running really close to time here, so I just wanted to, I don't see any further questions, so I wanted to thank Pam and Mark again for the very insightful presentation, and I will just give some closing remarks, and then we can move on to the network. So thank you again to all of our guests for tuning in to our 3rd annual Cross-Institutional Lending Conference. We're so glad that you could join us today, and we hope you learned something valuable. Later today, you'll receive an email with a feedback survey. Please do take a moment to share your experience with us so that we can improve future events. Next, we're going to cap off the conference with a 30-minute networking session so you can connect with our speakers, with your colleagues, and with your peers from financial institutions and other lenders from across Canada. If you weren't able to join us for the lunchtime networking session, here's what you can expect. We're going to move to conversation mode for some open networking, where you'll be able to move freely between conversations, much like you would at an in-person networking event. You'll be moved over to the networking mode automatically, so there's nothing that you need to navigate. Once you're there, you'll see that floor plan, and you can just click into various tables and, of course, move as you see fit. Thank you again for joining us today, and we hope you can stick around and come chat with us at the networking event.